Hello, this is Matt on the Moon Lambeau channel. The judge has dealt yet another blow to the SEC, which of course continues to fumble and bumble along, leading me to question to the SEC lawyers, do you even lawyer, bruh? Do you? I'm not convinced they lawyer. Not very well, at least. Which is why, and I mentioned in a video just yesterday, they actually have called in reinforcements. They're adding 2 new lawyers to the team because the first 3 have just botched everything that they've done up to now, just about. Like, it's not looking so hot for them, let's say. Also interesting, I mentioned this in my other video, at least one of the new lawyers that they're bringing on, who has been around for decades, so a seasoned attorney, safe to say. It looks to me like brought in to clean up the mess, but one of the things that he specializes in is settlement of cases. So that's fascinating. It makes you wonder, is the SEC going to be wanting to wrap things up soon? Well, given that it's blow after blow, including what happened today, which I'm going to catch you up to speed on, that wouldn't surprise me in the least. At some point, you got to decide if it's even possible for you to get what you wanted initially out of this particular case. But I think that it's pretty clear that Ripple's been right on the facts from the beginning. And so would not be surprised in the least to see some sort of settlement. But I'll share with you the smackdown that was dealt in just a moment. I'll share the details. But first, I do want to be clear at the outset. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos as a super duper fun hobby about Ripple and XRP and crypto and the judge bitch smacking the SEC. But that's all that's going on here. I do want to mention something briefly though. There are all sorts of people impersonating me, all sorts of fake Moon Lambeau accounts, and I just want to let you know that I'm never going to reach out to you with trading advice or anything like that. So if you get any message along those lines, just assume from the beginning that it's a fake Moon Lambeau stepping on my trip. You know what I'm saying? So I wanted to give a shout out to Missy on Twitter here, who brought to my attention a fake Moon Lambeau account, which has gotten traction. And in fact, here now, here's what they do though, because there's all the YouTubers, they all have scammers out there that are impersonating them. And so what they do is they'll make an account impersonating you, then they block you, the person they're impersonating, so that you don't catch wind of it as quickly. Ideally, at least that's the hope from their minds, because otherwise, then the jig's up and the community finds out and you report them. So I just wanted to let you know, because this person is actively trying to scam people, acting like they're me. And you can see here, it's amazing. They've got an account that's been around since December 2011. I don't know if they stole somebody else's account. Don't know how that happened, assuming that's accurate. But they have 16,100 followers. WTF, mate? What is going on here? So I just wanted to let you know, if you get this is at Moon Lambeau OI. That's fake. I am at Moon Lambeau IO. Small difference it's in terms of the handle, but big difference in terms of which one is real and which one is not. So just be careful out there. I don't want anybody getting scammed, so I thought it was worth taking just a moment to share that. Here's attorney James Filan. I've actually got opinions from a few attorneys in this particular video. So check this out. This is from attorney James Filan, not associated with the SEC or Ripple. He's just been filing the case, so a member of the XRP community. And updated here, wrote, as far as the SEC versus Ripple case, Judge Netburn issues discovery ruling, confirming earlier ruling, and delivers another rebuke to SEC. Tell you what, I'd rather be in Ripple's position than the SEC's. And so here's what was ordered by United States Magistrate Judge Sarah Netburn. She writes the following. And by the way, if some of this sounds like this is something that came up a few weeks ago, that's because the SEC didn't want to listen to her and tried to get around what she already ordered. And then she had to basically reorder it. It's amazing how polite she was. Wait till you see what attorney Jeremy Hogan had to say about this. But check this out. So here's what Sarah Netburn wrote. Having reviewed the parties' submissions, the court makes the following clarifications. The SEC must produce communications with third parties, including external agencies and market participants, subject to a privilege assertion. Yeah, so to be clear right there, what she's citing effectively is that there could be exceptions bring to her attention, and there could be certain documents that don't have to be included, would not be discoverable within this case. Number 2, the SEC need not produce informal intra-agency communications such as emails, and such communications need not be searched or logged. And so basically, and we talked about this before. So again, if this doesn't sound new, there's a reason to this. It's because the SEC is being a bunch of baby back on barrel trails. That's exactly what they're doing, and that's why we're having to cover this again. This is why we can't have nice things. Now, so we already knew that in terms of informal communication, such as email, there could be personal communication back and forth. That stuff is not, in a general sense, maybe there'd be a rare exception, but probably not. That stuff is not to be included in discovery, right? Number 3, intra-agency memoranda of formal position papers discussing Bitcoin, Ethereum, and XRP must be searched for and produced subject to a privilege assertion. Examples of such documents include division reports, final reports of internal working groups, or formal position papers submitted to commissioners. Although such documents may ultimately be privileged, information that would be provided on a privilege log, such as dates and participants, may itself be relevant and is discoverable. And so there you go, just giving some examples of things that should in all likelihood be included. Anything, those types of reports, communications on the topic of Bitcoin, Ethereum, and XRP, yes, include it, unless there's some sort of privilege assertion, in which case, fine, let's talk about it, she's saying, and won't need to be included, potentially, right? Number 4, any documents withheld on the basis of privilege must be identified on a privilege log. And number 5, the court directs the parties to continue to meet and confer on the remaining issues presented in their letters. Respectfully, the clerk of court is directed to grant in part the motion at ECF number 126, so ordered, and then signed, the United States Magistrate Judge Sarah Netburn. So there you go. So like a lot of those facts, the way that it was ruled, it was already ruled. It's like the judge effectively had to redo this because the SEC is a bunch of baby back barrel trails. That's exactly the number one reason. Somebody turn that into a ringtone, would you? That's exactly the reason why that's happening. Now, here is what attorney Jeremy Hogan had to say. And yes, this is really his account. I had to do a double take because it looked like it was hijacked. Like, he changed his name to Yummy. Like, you can look at your screen, like, that's what he did. This is really his account. And then there's some sort of cartoon-looking character. So I don't know if that's a temporary thing. I went to his page, and, like, there's no explanation. It's just, it's there in the public for all of us to wonder. You gotta love Jeremy Hogan. It's required. And if it's not required by law, it probably should be. But anyway, in response to that, what I just covered there, Jeremy Hogan tweeted out the following. The SEC made 2 arguments as to why it didn't have to disclose the internal memoranda, re. Bitcoin, Ethereum, and XRP. The judge denied both of those arguments and is saying, no, you really do need to disclose those documents. P.S. This judge is very polite when rebuking a party. Yeah. I would say so. I mean, and you'll see here, actually, he commented on, I think it's on this one. So, in response to that, somebody responded to him, wrote, "What a waste of time, though. Shouldn't the judge just make a ruling? Why does she need to rebuke it?" Right? So, yeah, so another ruling in Ripple's favor here, obviously, just confirming what she already insisted, which you got to think this irritates the judge, right? If you're the judge, I mean, you're also sitting there saying, this is why we cannot have nice things. And so attorney Jeremy Hogan responded to that question and wrote, "I thought it would be a rebuke because she was fairly clear at the hearing itself, and the SEC just decided to ignore half of what she said. I've seen judges get really irritated for much less than that, but Judge Netburn seems fairly even keel, apparently." They're really, like, testing the water. I'm just telling you. Look, I'm not saying that the judges are going to make decisions outside of what they believe to be logically and factually the most reasonable route to go forward, and from a legal perspective. But still, do you want to judge on your bad side? Because humans are still humans. I'm just saying, if it's me, I'm going to try and not be an asshat. These attorneys, though, asshat city, man. An entire city full of nothing but asshats. Here's another attorney, XRP attorney Seal, who wrote the following. "Just a gut feeling, but I think there's going to be some serious settlement discussions in the coming days." And that was just a couple hours ago. Somebody named Lee responded and wrote, "Let's hope so, mate. We can then put this whole sorry episode behind us. Do we get any sort of clarity That's the interesting part. Would have been great to see John Deaton get his day in court and try and put them in a corner. And XRP attorney Seal wrote, make no mistake about it. If a settlement does come to fruition, John Deaton's heroic efforts are one of the main reasons why. And I'm just going to assume at this point that you know what I'm talking about, or what XRP Seal is talking about there in terms of what John Deaton has done. I've been covering it very extensively on this channel. If not, just watch some of my previous videos, or just keep watching new videos, because he's going to be in a lot of discussions in the future also. But I don't want to, divert too far off the path of what we're talking here, so I'm going to move on. Somebody then responded to that and wrote, let's do a mock trial, but I want to play the villain witness. I'll censor this here. A-hole, Jay Clayton, to which John Deaton jumped in and said, should I comment? After all, taxpayer dollars are being spent to have someone sit down and read my tweets. Did I actually type that out in real life? Yes, you did, because that is what's happening. Taxpayer dollars are going to the SEC to have them look at your tweets, John Deaton. That is actually real life. So this is ridiculous, but what about this? What about this isn't ridiculous? Good times. So it is nice to see Ripple to continue to come out on the better sides of all of these pre-trial hearings and everything, all the orders from the judge. To this point, it's just win after win for Ripple. Like seeing that. And I think that on top of that, Ripple's team has just been very respectful in terms of not wasting the judge's time. And that just shows pure class right there. But they're also on the right side of the law. So anyway, I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything, because if anything that I say are right, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.